Good afternoon, everyone. Thank you for joining us today for the webinar with regards to the Register of Overseas Entities. For those who don't know me, my name is Alan. I'm the Commercial Director at Sovereign Trust here in Hong Kong. We have Stuart Stobie, Managing Director of Sovereign Corporate and Trustee Services Limited, with Josephine as well, who will be doing the presentation on the Register of Overseas Entities. Just some very quick housekeeping rules. The webinar will be for about 30 minutes, and we'll leave some time at the end for some questions that you may have on this topic. And for those who are attending, just to let you know that this session will be recorded, and you will be sent a copy of the presentation and a copy of the presentation as well. Stuart, Josephine, I'll pass it over to yourselves. Thank you.
Yeah, thanks, Alan. What I'm going to do, actually, everybody, if you don't mind bearing with me, I'm just noticing that the attendees are joining us. I might just hang on for a couple of minutes while we wait for the attendees to join us. So I appreciate that not everybody can be bang on time. So I think we'll just hold fire for a few minutes while there's come in. But first of all, everybody who's in attendance, thank you very much indeed. I'm assuming that I have spotted a couple of people who aren't located in Hong Kong, but I think I'm assuming most of you are in Hong Kong. So thank you very much indeed for taking time on a Tuesday evening, he says. I'm trying to remember which day it is. We're losing track over here in the UK. Things are that crazy politically. I don't. You've probably seen it all over the newspapers. So, but again, thank you very much for taking time to attend. I'm just going to. What time is it now? We're just going to give it another minute just to see where we are, and then we'll go ahead with the presentation. I think it's sort of holding steady where we are right now, so I'll get going. Obviously, then I just lost one. So we'll start off with the presentation on the Register of Overseas Entities. Basically, as the title implies, the issue here is that if you've got a property in the UK and it's owned by an overseas entity, you should definitely be reviewing how that property is owned and whether that property is required to be registered. And in this presentation, I'll endeavour to take you through the process of what you've got to look for when you are reviewing the structures. There's a brief summary on the screen there for you. Now, the Register of Overseas Entities has been spoken about in terms of for a number of years now, but what really brought it into play was Russia's invasion of Ukraine, and there was suddenly a political need to show that they were taking actions to look behind a lot of the entities that are owning property, primarily in London, but obviously around the UK as a whole. And so this was rushed into being, there was headlined everywhere in the UK when this particular Economic Crime Transparency Enforcement Act was brought into play, saying that we were taking action against it, looking for sanctioned persons and entities, particularly obviously it was directed at Russians, but beyond that, and they've been talking about looking behind the various entities for a while now, but it was explicitly expedient back when Putin invaded Ukraine, or Russia invaded Ukraine, to push this through. And as a consequence, what we have is probably not a very well drafted piece of legislation. The regulations aren't the best. So from our own experiences, the regulations can either be vague or not exact, or not always applied exactly. So but we'll hope to help cut through the red tape for you and sort of briefly summarize how this all works. So As I said, the Register of Overseas Entities, which are or ROE, as we briefly refer to it nowadays, it was sort of brought into being in the Act, and it is run by Companies House. And as it states, any overseas entity owning land or property, which I'll refer to just as real estate going forward, in the UK has to declare the beneficial owners and/or managing officers and details on that entity, be it company, pension, or trust. And just to reiterate, this is only overseas entities. So if you have a property in the UK owned by UK legal entity, UK company, trust, or pension, this piece of legislation does not apply to you or that particular entity. So it is only overseas entities. For some reason, which I'm sure somebody should have, I should have been quiet, but the application, which entities it applies to, depends on which jurisdiction within the UK you're looking at. So as you can see, that there are various different dates depending on where your property is located. So England and Wales, January 1st, 1999, Scotland, December 2014, and for some reason Northern Ireland, the 1st of August 2022. So just be aware of that, though. I said most of what we see obviously is in and around the southeast of the UK, so England is the applicable jurisdiction there. So basically, to summarize, to continue with this summary, but if you have an overseas entity that is either that is owning property and wants to buy, sell, or transfer that property, they must register. So even if you have a company that is seeking to purchase property, real estate in the UK, that entity must register in advance of acquiring that real estate. And even if, say for example, you have an overseas entity that bought the property in 1990, it doesn't have to register right now, but if it wants to buy or sell that property, sell that property, it still will have to register. So it will at some point, it does actually go back to, it does apply to those entities and seeking to sell that own properties pre 1999 in England and Wales, for example. The rule of thumb here, though, is this looming, as I say, any entities have acquired properties in any of those jurisdictions on those post those dates in the previous slide, they do need to register on the ROE, which is run by Companies House, and it has to be done by the 31st of January 2023. I will come on to what happens if you don't file by 31st of January 2023, but that's the deadline. And I have to tell you, that is looming fast. And currently, we are seeing, the Companies House have been pretty efficient so far. Yes. But as we know, there's probably going to be a tsunami of filings going on, and therefore they will slow down. And as I say, we can't always trust the IT systems pushed out by the government, and we'd hope it doesn't fall over. So we thoroughly recommend reviewing files now to see if you have companies, overseas entities owning properties or real estate in the UK now, and getting that filing done as soon as possible, so you're not caught in some sort of log jam. So again, 31st of January is the date you need to be aware of, but we are suggesting to everybody to review files now, and if there's a need to file, to file. I mentioned before that I was going to touch on deadlines and sanctions. To reiterate, again, I'm sorry to bore you, but again, 31st of January 2023 is a key date. Have in your calendar. and the one you should be counting down to, that you need to file by the 31st of January. And as you can see from point 2 on this slide, failing to do so is you'll be deemed to be committing a criminal offence, criminal offence. And any officers of the legal entity who do not file on time are open to prosecution here in the UK. There is also a financial penalty to be wary of, and they start out at £2,500 per day. So if you haven't filed for a legal entity and you don't have good reason, even if you do have good reason, I'll come on to that point in a minute, then you could be subject to substantial financial penalties, as I say, £2,500 a day, and also officers could be deemed of committing a criminal offence, because, as I said, they're very keen to find out who's behind these legal entities, and they're obviously, hence the reason why the sanctions are so strong in terms of the criminal offence and the financial offences, penalties for non-compliance. And furthermore, just to underline the fact that if you deliver false or deceptive information to country's house, then again, that's the criminal offence as well, and they'll find ways of prosecuting you. People saying, well, if I'm not sure how you're going to get me, well, obviously there is a UK citus asset in form of some real estate here, and if they can't get hold of the individuals, they will just apply all sorts of restrictions which are listed there on the property in the UK, and obviously the government has ultimate sanction in terms of acquiring that property through the courts if it gets to that point. So you're basically, there is a need to comply, and so again, and there's a need to get a move on, because we're only a few months away from that looming deadline. On the deadline, there has been representations made by various sectors. I know the Society of Trust Estate Practitioners made representations to government saying you just haven't given them enough time, and those have been taken under consideration, but nothing has been published saying that they are going to do anything about it. So the presumption is, and the presumption should be, that the deadline will remain 31st of January for getting every entity that is currently owning real estate in the UK registered on the RAV. So keep that deadline in mind, because I don't think it's shifting anytime soon, and I wouldn't assume it is going to shift. Sorry. Sorry, it's decided not to. Here we go. Sorry, right, okay. So in terms of information you need that will be disclosed, the Register of Overseas Entity is available to the public. So everybody and anybody can go along and look at it. So if you've got an offshore company owning a piece of UK real estate, somebody can go look at that, the Register of Overseas Entities, and see the names of the legal entity and the officers, and the registrable, can't say it properly, stick with beneficial owners filed there for all to see. So if you are informing clients, there is a requirement to inform clients that you will be required to make the disclosure, and that this information will be made public. As you can see from point 2, this does not apply to trusts. If say for example, if a trust is having to file the information, there is a need to file information on settlers, beneficiaries, protectors, other interested parties. Am I missing anything, Jen? No, I think that's pretty much it. But that goes on to, I kid you not, onto an Excel spreadsheet. It's like going back in time. and that is filed with the Companies House. Nobody can see it, but as you can see from the last point on this slide, HMRC have access to that information, so that if there's a non-compliance issue there, which you're concerned about, you need to address that, because HMRC do have the right to ask Companies House to disclose all the private information which has been provided on the Register of Overseas Entities, which we publicly cannot see. So as I said, there is, I mean, and there is so the trusts are not exposing everything to the public, which is good, but you do have to be aware that HMRC and other government agencies can see that information if they so wish. And what I understand is that there is some sort of moves afoot, or if not already, by HMRC to have a team set up to go and dig through these files. So compliance, this was more a compliance issue in terms of finding out who the individuals were behind all these various entities. There is also now a tax compliance angle you need to be aware of, which is an indirect effect of this. And it's just popping back up to point 3. So all the, in terms of the information on the legal overseas entities holding UK real estate, that will be, and the registered beneficial owners is filed for all to see. When it comes to trusts, all you see, and Joe will confirm this, you will see the name of the trustee. You will not see the name of the trust. So it'll just be the legal name of the trustee. So it is quite, the information is quite confidential. So that is one, as I say, one good thing that's come out. This has been actually well thought through in protecting what is going on within the trust. Good reason. Right. Basically, ownership test, rule of thumb, 25% of the, if you an individual or legal entity holds 25% of the shares in an overseas entity, or the shares you own have 25% of the voting rights or more, then you are deemed an RBO, as you can see down the bottom on the bottom line, pretty much in highlight about what that is. You are deemed the beneficial owner, and information on you will have to be filed, and that is available to public. There is also, basically, if you have a certain amount of sway in the way in terms of appointing directors, again, that makes you have sufficient. That makes a requirement for you to be filed as an RBO. And again, if you have any rights to exercise certain amounts of influence or control over that particular legal entity, again, information on you has to be, you'll be deemed an RBO, even if you're not actually directly benefiting from it. If you basically, if you have any sort of say over how companies run, or a board of directors is structured, then you're an RBO. And again, just to reiterate, 25% rule in terms of shares in the company, or 25% of the voting rights of that company. You will have, the filings will need to be made, and then again they'll be open to public, and you will be deemed, or that client will be deemed, an RBO. Similarly, moving on to trusts and pensions, and again, just to reiterate, it does this is overseas trusts, overseas pensions. We're not talking about UK trusts and pensions here. So again, if a trust is owning a structure, a legal entity, and it owns more than 25% of the shares in that entity, or has more than 25% of the voting rights in that entity, again, that trust and or pension will have to be, information on that will have to be filed at the Register of Overseas Entities. Again, does the trustee, again, similar to the previous file, slide, sorry, does the trustee have any powers over the company in terms of appointing or removing boards of directors, or individual directors? Or again, on point 4, again, it's just basically if it's similar to the last slide. Again, if they have any significant influence or control over the company, then if any of those conditions are met, trustees deemed RBO and necessary filings have to be made. So again, you need to look at that and see what happened. Just again to be wary of that one as well. That the protector could again. There's a protector. There's a lot of trust with protectors in there.
Protectors will be disclosed on the Companies House website.
Yeah. So a lot of protectors are obviously put in there, thinking it's a good idea to have a third party in there to keep an eye on things or act in the family's interests, or just have an oversight over what the trustees are up to. Their name will be splashed in lights or in registered overseas entities because they have significant influence.
Yes, and control.
Over that particular entity which owns the property. So again, they need to be warned. That is what there's information on them being filed. So a statutory document has to be filed. How are we doing for time?
Time. We've got 10 minutes.
Right. Now that's the registration process. I've made that slide to look nice and simple, but as Joe here, who's responsible for the team who does all this, who actually goes through all the filings and registrations, will tell you it is not always simple, and sometimes the regulations that you see in writing aren't always applied in reality, and vice versa, if that makes any sense. So just be aware that it's not always complex. Though I'd imagine most of the ones we see, I think, Joey, are pretty much company owning property, so fairly straightforward.
Yeah. It's the partnerships that create a bit of complications.
Yeah, it's limited partnerships, things like that. It gets a bit more complex. But we don't want to take you into the dive deep into the complexities. Otherwise, we'll be here all day. So we'll just quickly review the registration process. So as I've referred to earlier, in terms of the registration process, the first step is to register, which is an online process, details on the entities and the RBOs.
It's actually the verification process that's got to be done first before the registration process.
Yeah, sorry, I do apologise, one way around. We've got the head of ops here. And so the verification has to be done by a Companies House assured agent. Now, what is one of those? Well, we are one of those, and the reason why we can be an assured agent is because we've gone through various loops and hoops to get approved, deemed fit and proper in what we do here as a corporate service provider and trustee, and we've ticked the box of HMRC, which that means in the eyes of Companies House that we're all fine and dandy, and therefore they have approved us and regulated us, which makes us an assured agent. And you need an assured agent to verify any registration that occurs on behalf of any legal entity, and then allows for further registration of that entity on the ROE. So unfortunately, again, representations I know have been made by the likes of the Isle of Man government to the UK government saying, why do we need to have a UK Companies House assured agent based in the UK, or why can't we be one of these? Ultimately, it's very obvious. The Companies House want to be able to get hold of somebody in the UK if any of the information which is being filed is incorrect. I wouldn't say the total buck stops with us as the assured agent, but we have to make sure that any information that we on the entity and on the beneficial owners of that entity is correct, and we must go above and beyond, basically. I think
it's a verification process.
Yeah, that is, yeah. So there is a very, and so we can't just simply take your words for it and say, yeah, that's fine, I tick the box, because if we can't prove to Companies House that we've actually gone through a robust process to verify the information that's provided is correct, then we're in a little bit of trouble. But yet again, ultimately, the rationale behind having an assured agent having to be located in the UK is because we are the door they will knock on if there's any issues, and they're not going to remove that requirement. So unfortunately, for people outside of the UK, CSPs, trustees, and others outside the UK, you're going to need an assured agent based in the UK, such as us. But that basically is it. Anything you want to add to that, Joe? Because obviously you're the one who's dealing with this day to day.
No, if there's been any disposals, did we mention disposals of properties?
No, we didn't.
So if there have been any disposals, we can't do a registration online. So we need to do a verification and a manual submission to Companies House. I can't remember the date actually of the date of the disposals. But anyway, if anybody's got any questions about that, just drop us a line. Yeah. And I'll be able to confirm it.
Just want to quickly reiterate the process for verification filing. Just
essentially, if you want us to act as we can do the registration and the verification. So we ask you to fill in an application form. You submit all the company's information, certificate of good standing, all the statutory documents. They must be certified. And essentially, once we've done the verification, we tell you that that's absolutely fine. We can either go ahead and do the registration as well, or you can do the registration and then we finish off the process. It's probably better and more straightforward if we do the verification and the registration, and then that needs to be redone every year as well.
Yeah. So they'll come on to that bit in a minute, but yeah. So it is. There's always anomalies in these processes, so we always suggest talking to people who have experience in this, and say Joe's done over. I've been giving the best part of over 25 now, and we know that volume is going to increase. But obviously, right now there's a lot of information being collected, and then we will say we're seeing a slow build, and therefore you need to start acting now to make sure that you're not caught in a queue, because obviously people like ourselves, we're very content with how our systems work, but there's only so many assured agents out there, and therefore they can only deal with so much volume of work. So you need to act now.
And also bearing in mind the more complex the structure, the longer it's going to take to do the verification.
Yeah, and also you're having to. The other thing you've got to remember, you have to go and collect up-to-date KYC on your clients. Explain to them why they're having to do this. You're going to have to send a letter out to them saying, by the way, we're having to file information about you and your entity with Companies House in the UK. So there's a process there as well. So it's not just a simple thing of just saying there's an entity and file. There's a fair amount of paperwork that needs to be gathered together. So, and this obviously will take time, and you'll be aware of that. That's going to work for me. Right. As Joe's been referred to, there is an ongoing process. It doesn't just end with a one-off filing. These must be verified. The filings on the register of overseas entities must be verified annually, and they have to be done by an assured agent, in this case us. And so there's a requirement to keep us up to date on what's going on. We will basically every year write to anybody who's utilising our services and say, can you just confirm everything is as it was previously? Basically, if there have been any changes, though, you should have told us anyway, because you have 14 days to do that. So that comes in, that particular regulation comes into play, I think in mid-Jan. But just take if you had filed that already and you've made there's been amendment to how the company's structured in any way, ownership or management,
Or disposal.
Or disposal, sorry, you need to file anyway. I mean, so I suggest just keeping everything up to date, but I'm surprised if anybody's in that situation. But yeah, so there is an annual process that has to be undergone, and it has to be carried out by a Companies House assured agent, which, as I've stated and Joe has reiterated, we are one of these, and therefore we can assist in that process for you. It's really not liking it. Right. I think that brings us to the. Oh my God, I'm on time for a change. As I say, we probably simplified it quite extensively, but I think it's it's not exactly the most exciting subject in the world. It is a compliance piece. It has to be done. You've got until 31st of January to do that. Otherwise, major financial and criminal sanctions come into play. And as I say, right now the Companies House systems are holding up well. We have no idea what volumes they're being hit with. Joe and the team have a good relationship with Companies House, and therefore any queries we have are rapidly answered. So that's a comfort. But again, again, we know for a fact from the conversations we've had with our own offices, the length of time it takes to gather all the requisite information together. I mentioned previously updated KYC, for example, and therefore you need to act on that now, because come January, I imagine there is going to be a large wave of filings, and then we'll have to see whether Companies House can cope. And as I said previously, it doesn't seem like there's any intention right now by the government. When the government probably tied itself in knots, to be honest. So, but doesn't seem to be any intention by anything we've heard out of Companies House or anywhere else for any extension to be made. So the message from this is, if you have entities, overseas entities, again, not UK entities, overseas entities owning real estate in the UK, you need to act. With that, as it says, any questions? And I've got.
Yeah, Stuart, I've got a couple of questions that have come through. So someone's asked, what do I need to do if I own more than one property?
So that is actually through the same entity. Again, the purpose behind this particular piece of legislation and the regulations that have come out of it is to find out who's behind who's the beneficial owners, who's behind these legal entities. So if you have a legal entity owning multitude of properties, that doesn't matter. It's just one filing on that particular legal entity, and that's it. It doesn't matter if there's 20 or 1. It's just one filing. We're just filing in regards to the legal entity. So it's not an issue, and it's not like we're having to run around checking that the properties are there. But obviously, all that information is already with the land registry. They are aware of that. That's where when you're getting letters from. There's a requirement to file. That is where they find that information out from. The land registry obviously has a register of all the companies and trusts and pensions that are owning real estate in this country, and that is where that information is coming from. But yeah, sorry to be more succinct. If for one legal entity there's just one filing, it doesn't matter how many properties are owned.
Okay, thank you, Stuart. Next question: do I need to be a sovereign client in order for your office to help me with the filing?
No, not at all. We are, as you can imagine, there are a number of company and trust service providers around the world who don't have representation here in the UK, and we are working with a large number of them to help assist in filing. So no need to be a sovereign client. And also, for example, we know for a fact here in this country that the Law Society have told lawyers not to get involved in the filing, and therefore we're getting approached by a large number of, some sizable number of big law firms in the country to assist them with the filing. So But to confirm, no, you don't have to be a sovereign clerk. We're more than happy to do this work for you.
Okay, thank you, Stuart. And just finally, can you just confirm the deadline for the filing and also what the penalties are for not filing? Yeah,
sure, no problem at all. Again, it's something which I bang on about forevermore, I imagine, but we're not forevermore. Until the deadline. The deadline is currently the 31st of January, 2023. So yeah, a couple of months away. And you have to file even something before then. Otherwise, you have there's a criminal sanction against the officers involved of that company or trust or pension. And there are also financial sanctions starting at £2,500 a day. So that's pretty substantial. I don't think yeah, it is very hefty. We see all sorts of filing penalties. You get them in Hong Kong obviously as well for not filing accounts, etc. on time. But that's like £100. Everybody goes, I can deal with that. But £2,500 a day, rapidly mounts up. Plus the other sanction is that you've got, obviously, as I said during the presentation, you've got UK status asset, and that asset is obviously is seizable by the UK government if they're not getting the financial sanctions paid, or that you're not responding to it, or the officers aren't responding to any criminal sanctions or charges that are laid against them. Basically, what we understand from the regulations is that even if you've got a legal entity, if you're an officer of the company, you've got a legal entity, and that legal entity, with what you have on file, is saying Mr. A and Mrs. A are the shareholders, but you're not sure that, that was 10 years ago, when you're looking at their past and thinking, oh my God, the chances are they might have passed on or something, or things might have changed, other family members might now be shut. And even if they're not responding to you, even though because maybe they're directors, they've done things with the company, you're just not totally unaware of it. You basically, if you're anyway involved in that company, can be deemed a company officer. It is best just to file saying, and Joe, correct me if I'm wrong, saying basically, I understand the entity to be structured like this, and we are doing our best to check with the beneficial owners as we know them that is still the case. And then you can file that, but you need to file something, even if it's to say, we think this is how it is, but we're trying to find out that this is correct. So you just need, and that has to be filed for 31st January.
Yeah, we went through the conditions, but there are also accompanying statements as well. So for the company managers, you can either identify that you've identified all the RBOs and there are no more, or you can go through to say, well, we've identified some, but we can't identify others. And I think the final one is we can't identify any of the RBOs, and that's when you have to put down either the company officers or the company managers as being the RBOs of the company. So there are 4 statements that accompany the conditions.
Yeah. Thank you.
So basically, just to reiterate, what basically we're saying here is you have no excuse for not filing if you don't have all the information you think you have. You just need to, you have to file, get something in there, company with a relevant statement, and it has to be done for 31st January. Even if you're sure that what you're filing, that structure's been structured, but you just don't have all the information. You need to file, and file with a necessary statement accordingly.
Okay, I've just got one final question, and then perhaps we could just wrap it up. It's a bit of a slightly technical question, so I'm not sure whether it's one for Lawrence or not, but someone's asked, if an overseas trust has a charge against a UK property in respect of a loan, does it need to register?
If the company is an overseas entity and the charge is already in place, it won't need to register if the land has been bought before the 1st of January 1999. But if there's any discharge of the charge, then I think it will need to be registered. because you're actually then discharging a loan. So I think it may need to be registered, but I think you're right. It's quite technical. So perhaps Lawrence.
Yeah, I would just to Richard, I think basically if that trust does not have title to the property, it is merely a charge over the property.
It will still be at land registry, won't it?
Yeah, but the charge, but it's not. It doesn't have the title, and therefore it doesn't have to register under this term.
No, the overseas entity may.
Yeah. But if in this case we're talking about, just to reiterate, if I get this right, there's a trust with a charge over a property. If that's what they're saying, if that trust does not have legal title to that property, it would not have to file.
Right.
Okay. I would suggest though that whoever's asked that question to approach us, we can get that clarified for you. But basically, the rule of thumb is that this only applies to legal entities owning, therefore have title to the real estate here in the UK. So if there's any charges or anything like that, then this piece of legislation is not catching those. But I would like, but at the same time, I'd feel more comfortable if they could contact us directly.
Yeah.
And we can just cover that off. But to make sure that we're not misleading. But basically, the rule here is legal entities owning, therefore have title to real estate in the UK. This is what this piece of legislation applies to.
Okay, thank you, Stuart, Josephine. That wraps up the session. So thank you both for your time. I know it's early in the UK. Thank you everyone for joining. Like I mentioned earlier on, a copy of the recording and a copy of the presentation will be sent out to you. Please feel free to get in touch for anything that we've not covered or anything you want to further clarify. So, yep, thank you again for your time, and hopefully we will hear from you soon. Thank you, Stuart. Thank you, Josephine. And thank you, everyone, for attending.
Yes, thank you very much indeed.
Thank you very much.
Take care all. Bye now.
Bye-bye.
Bye-bye.